just saying, really good to see some, new faces and some familiar faces from the 361 community. For those of you who don't know me, I'm Patricia Geli. I am the co-founder and COO of C10 Labs, which is an AI venture studio. So we're a company that builds companies, and C stands for speed of light, and 10 for the number of companies, our lower bar of what we're building per year. And I'm really delighted to have Kimo Gandel here with me, who is one of our COOs. And he's actually also not just one of them that we have invested in, but he happens actually to be the first one. and so just to give you a little bit of a sort of visibility into how competitive this has been. So we launched last year. We had our first cohort starting in November 6th. We had over 150 entrepreneurs applying, and this was before we even had a proper website, but highly competitive. We had 80 or so of those entrepreneur teams were from the Harvard MIT ecosystem. And we are building companies to solve real world problems, sector agnostic, process based, and so legal, tech. And really, I will emphasize that what Kimo's doing is really horizontal, and he will tell you more about it. But Kimo's company, Fortuna Insights, is the first one that we actually invested in. And so really delighted to have him here and share more about the things that he's doing. But he's one of 5 companies that we ended up investing in this pool of more than 150 very, very strong entrepreneurs that applied to build companies with us. So they go through a cohort program and they graduated in March. And we are also want to add that we're actually now raising a pre-seed round for Fortuna Insights. So maybe if I can start by also, we'll talk a little bit about the company, what makes them unique. And really, actually, you hear a lot about AI companies today, right? It's almost like, in the .com, right? It's .ai. And so the questions that I get actually on your panels, Mark, and from investors generally is, what makes an AI company, right? If you look at there's a website called, there's an AI for that. There are more than 40,000 AI sort of tools and tasks listed. Most of that, I would say over 95% is what we at C10 Labs call screen AI. So it's these 2-dimensional tools that are either increasing productivity, creativity tools, another tool for writing a more efficient email. Those are things that are really easy to build and easy to disrupt. They very often depend on the current version of, OpenAI's ChatGPT. But when the next launch from OpenAI comes and it's 100x better than the last one, I don't know if you have tried ChatGPT 4.0 yet, but if you haven't, you should. Most of those companies just go bust. So this is not one of them. And Kimo will tell you exactly why. So maybe on that note, Kimo, if I may turn to you, and if you can briefly introduce yourself and give us a brief overview of your startup. Over to you.
Absolutely. Thank you.
And the market, right? We want to emphasize how you see the landscape.
Absolutely. So I'll make sure to dive in, give you guys a deep dive into that. My name is Kimo Gandel. I'm a 3L at Harvard Law School. I'm a professional registered parliamentarian, and I'm also, again, CEO of Fortuna Insights. I kind of want to begin by explaining kind of the traditional marketplace and how people view. Harvard Law recently published a data set to Hugging Face that contains the entire corpus of U.S. opinions, state law, federal law. Notably, there's still some important data missing. Briefs, for example. So briefs are what you would submit to a judge, and then he discerns an argument from that, and then he gives the opinion. So it's useful in training an LLM to parrot what a court might say, but it's not the best in predicting if a brief is going to prevail in that court. Because oftentimes how advocates write are very different than how judges write. And so just like on a data side, the market is quite complicated, especially when you start getting into verticals and horizontals and different ways companies are integrating it, because not all that data is available. But it is true broadly that the opinions are there, which is unique for the United States. A lot of other countries don't have that. A lot of LATAM isn't digitized, for example. There are some other countries, shockingly, that are. Actually, India is much more digitized than the United States. In India, you actually can grab the briefs. In India, you can not only grab briefs, you can grab municipal orders online. So the world of data in law is rapidly accelerating along with LLMs. There's also one part of the market on kind of an internal debate over methodology. And I think that's because the current mindset in legal tech is get a chatbot that you give an input and you get the most accurate answer. Stanford recently published a study showing that even what is considered like the market norm, that'd be the big guys, Lexis, Westlaw, they still hallucinate about 20% of the time. And that's because the traditional idea right now is to take your database, put the raw text, vectorize the raw text, and then RAG or raft on it. And one of the problems with that is the AI, okay, it'll take some of that those documents as fed, but then it'll also input its own answer. As opposed to just saying, only read these documents and have another one to make sure it only reads those documents and returns the parenthetical. So there are different agentic methodologies that companies are adopting to minimize hallucinations, but maximize clarity. Because one problem with the latter methodology, we have a memo service that kind of does this, is the clarity is not there. And the reason is sometimes in law, there's not a clear answer. You're having to make very abstract analogies. And the problem with LLMs generally is how tokens work. Tokens try to predict the next probable token. And so if it's not probable, so based on the corpus of law, that there'd be a clear analogy here, it might make one up. And that's one of the reasons a lot of these problems appear, especially when you get into things like pin sites and parentheticals. And I also want to open this up to explain one of the niche difficulties in legal research in particular, which is this concept. It comes from this guy named John Shepard. He created the Shepardization program that was acquired by LexisNexis in the 1990s. And essentially what it does is it compares two different cases without different facts, but the same rule. And then it asks, why was the rule applied differently in each case? And so one of the difficulties companies have with just ragging raw legal text is the analogies are not very good. So it gives you a good, what seems to be a good, clear answer, but that answer is not actually what is most binding in that jurisdiction. So what Fortuna tries to do differently is do some of that hard work and actually discern the relationships between different cases, which means going through each case, pre-processing them, extracting head notes, and then matching those head notes to similar rules. Head notes are the legal term for a rule related to a parenthetical, and then match similar rules to different cases with different fact patterns and determine what their relationship is. That is the truly difficult to tackle question that a lot of companies are struggling with as they try to make their product have better latency, which we actually have some good market data. And I have a lot with my clients data on this, that latency is important despite people thinking it would be lack of hallucinations. It really is not. It is latency. People love their quick legal memos coming out in 2 minutes as opposed to 30 minutes. And we have both products, one product that almost never hallucinates and one product that is a little below market average on hallucinations. And the little below market average hallucination one gets much more use because people love their instantaneous answers. So you're getting kind of this pull between what is ethically required of attorneys and what human psychology prefers, which is why we all view LLMs so magical. And this gets into some of how different companies are adapting. So you have Alexii, for example, they're very into no hallucinations. So if you actually get one of their long brief services, they'll actually be reviewed by a human for you. And that's kind of their solution to maximize hallucinations and clarity. Of course, it comes with an attached much higher price. And then kind of on the other side of that, you have Lexis. They're into just the straight RAG. And then you get great clarity, high hallucinations. And then Westlaw is kind of somewhere in between. And so a lot of this comes down to the quality of the legal research. Now, this moves into a separate question, which is how it's going to change the market and business models. This was actually a question brought up by one of the viewers. So great question. In terms of law firms, I think it's not going to affect billables at all. In fact, it might increase billables because my vision of the future is more of a war of bots. So people are going to have different models that are able to optimize for different jurisdictions with different particular actors. Different judges are very impactful. People underestimate this. That optimize for certain juror demographics and are going to be able to write briefs that reflect that. So I actually think there'll be more time spent in strategy, more time spent in litigation. And even if it decreases the cost of litigation, because we can do these things faster, I think we'll just see more litigation. The market will respond because there's a lot of litigation demand in the market. Actually, this is an access to justice problem, right? Where people's demand for legal assistance is not being met. So I think we'll just see increased services, especially to the middle and small sized firms. Now let's talk a little bit about integration outside of the law firm with companies. So a lot of big companies, especially domestically, internationally, have very niche legal issues built into their workflow that causes a massive bottleneck. Perfect example of this, my co-founder was actually an IT manager at Freeport Mac, right, in mining. And one of the really big problems in mining, legally speaking, is you have to fill out these job safety analysis forms, every single worker, every single day. And then it has to go to management. They have to review it. They have to compile them to a single report. It has to go back to the GCs. This is why you see so many delays. And being able to automate that process will expedite that greatly. And that's a legal research problem because the question is, what is the federal statute? What is the local statute? How are the courts interpreting this? A lot of companies keep entire departments devoted to just this question. And this is particularly big internationally, because since a lot of the laws aren't digitized, you have entire departments specializing in these very niche questions, and then there's dispute over what the agency regulation is. This is one of our clients right now. We're working in Peru, dealing with copper, right? So Freeport Mac, for example, got hit with $1 billion compliance fine, dealing with a tax lien in Peru exactly over this question. So a lot of the world is going to see AI come as a tool to help not only expedite, but actually improve safety and compliance in these verticals. And that's where I see kind of the survivors, right? Peter Thiel talks about this in 0 to 1, where it's not necessarily who's most immediate competitive, but who does best in aggregate, right? Who survives. And so the people I think who survive will be those with the best bots in niche jurisdictions with niche actors, or those who integrate successfully into certain verticals or horizontals that are most applicable to their situation. So Fortuna, for example, is very big into the horizontal. We do specialize with the law firms on legal research, but then we also take the next step and incorporate it into workflows so that corporations can actually use this firsthand. And then there's also questions about security. I saw this was a big one. So the standard answer to that most tech companies will give you is SOC 2 compliance, right? But the real question, and I have a good friend who's I did an interview with at King & Spalding, who asked a more particularistic question about how LLMs process data and are trained. And it is true, if you're using an API, someone else's, it's possible it's being intercepted by them and trained on. Now, theoretically, if you trust OpenAI, their contract says they're not doing that, but it's impossible for that intermediary company employing the API to guarantee that per se from a technical perspective. So for example, Fortuna Insights does not use OpenAI. We have our own models running on our own computers. And so we process all that data in-house so that we can reassure clients it's not being used to train on. Let's see. Oh, yeah, sorry. I know this was a lot of information. I'd love to take some specific questions. Let's just look at what the chat's saying. So in what way does your software, and by proxy many other things, differ from a purpose-built GPT that has been fed a unique knowledge base? Very good question. So this goes back to the traditional RAG question. If you just RAG the raw legal text, so you vectorize the raw legal text, put it in a RAG it, so you do a cosine similarity function, and then based on your input, pull those cases, and hopefully it cites correctly to them. But one problem is legal cases are very, very, very token intensive. I mean, I'll give you an example. One of the more infamous abortion cases, for example, Dobbs, it's 120,000 tokens. So it doesn't actually, usually how they'll do it is they'll RAG it, they'll pull the case, and they'll feed that into one context window so you get the most accurate answer. But the problem is that it can't write very well. The cosine similarity functions also don't work very well because it might be an issue niche issue related to that. So for example, if you had a Second Amendment case talking about originalism, it would need to cite to Dobbs because Dobbs is about substantive due process rights, the discussion on them, and originalism, but it wouldn't because it wouldn't pick up that function. So it also, the RAG doesn't work very well, lots of reasons. So it really works well when you look at the particularistic rules, match the rules to the relations within cases, and then RAG off that as opposed to the raw legal text, which is how a purpose-built GBT would operate. Good question. So who owns the data when you're not training your own model and using the existing LLMs? So the answer on the Fortuna side is we use open sourced LLMs that we fine-tuned. So we own those. And then data that's coming in, if they're lawyers, the lawyers maintain, we have a privacy clause, so they get to own their data. That being stated, we also have cheaper plans because some small and middle lawyers, they're like, well, all this is going to be public information anyway. We might as well pay less, be much cheaper than the big guys. And you can just train off our data. And some of them opt for that. So in that case, we own the data. So it depends on what plan lawyers are taking. This is a good question on who owns the data. We're not training foundational models, but we are fine-tuning open source models. So the answer is us. Now, if you were, there's a better question with OpenAI. OpenAI's contract would technically also say you. Can you explain how retrieval augmented RAG works in contrast with GBT's LLM? So a purpose-built GBT can use RAG. In fact, that's how I believe how the purpose GBTs work. They have a local RAG. It's just they're purpose-built. So they're looking at a particular set of information. Why is RAG preferred for legal? So I actually think RAFT, it's kind of a subtype. So retrieval augmented generation can also mean retrieval augmented fine-tune. So you fine-tune on the data that's in your RAG, and then you RAG on it. That's actually what we do. The reason is because legal is so hyper-focused on getting parentheticals right. So parenthetical for legal is an exact quote with the pin site. And that is actually a very difficult technical question. No one's really been able to exactly solve that without having these very complicated agentic methodologies that then your 30-second brief takes like an hour. So that's why it's preferred, because you want the exact information that it's pulling. And there are multiple ways to do that. I think the very, very rough way to do that would be how purpose-built GBTs are, and then run a local RAG. I think the better way is rafting. How unique is your ability to customize the token process? Is that, so we're not to be clear, we're not customizing the token process. That requires actually dealing with the foundational model. There's another company out there called Harvey that does pre-training, but that is not a good idea, in my opinion, unless you're a very, very well-established company, because the next LLM will come out and then the clarity aspect is already taken away. The goal here is not necessarily to build a better LLM, because we're not a foundational company. That's not the question we should be having. The question we should be having is, how do we build a data set that we can RAG that can most clearly demonstrate the relationship between cases? That being said, our agentic methodology is patent pending. So the way Fortuna does it in particular is, so that process is considered IP. And what I mean by that is, how do you have multiple bots look at a problem, have a similar RAG or raft, and then they have to agree? Kind of a similar idea you'd have on a voting ensemble. So actually my first paper that I published, which is SCOTUS AI, it's a psycholinguistic one, basically feature extracts using a sentiment analyzer, and then labels based on the output, and then is able to tell the chances of a certain brief prevailing in the Supreme Court. We showed that was 91% accurate. Now, LLMs work a little differently because they're not actually looking at your chances of prevailing. They're looking at what is most likely to appear as the next token, meaning like characters in a text. I hope that was clear. That might have been more obfuscating. Do you do post-processing to capture hallucination? So in our memo system, the answer is yes. In our normal chat bot, the answer is no. And this gets back to what the market is actually demanding. So I would say good lawyers should simply accept that their memos are going to take a little longer. In exchange, they are trading certainty that it's going to be accurate. But there's also a problem with misrepresentation or inaccuracy. And this is something the Stanford study explored a little. They call it incompleteness. Now, the problem in law is lots of humans write incompletely. They're not exactly analogizing one-to-one facts between cases. They're not representing facts necessarily accurately. This is why district courts get overturned by appellate courts. And the problem is if you're mixing all those opinions into one LLM, which is kind of what Wizard did when Microsoft fine-tuned and released that open source, then you kind of get this smorgasbord of representations. So the fact is you're always going to have a trade-off. The more agents you're using to capture hallucinations, the less complete it's going to be. So that's kind of maybe do both of them, maybe do one of them, maybe have different models. These are things we're exploring and seeing what our clients want most. What do clients say is the most valuable benefit of using your software? Outcome. They're definitely outcome oriented. I think for us specifically, because we have a very narrow niche, especially since we're working with Peru now, we have the emerging markets. We offer something that other firms don't focus on, which is primarily domestic law and shepherdization. Cost is also big. So a lot of people don't like talking about cost because the traditional VC mentality is cost shouldn't be a factor if there's a lot of benefit. But for a lot of smaller to medium-sized firms, it is. Now, the big firms, the cost isn't their primary calculus, but cost is very important to a lot of smaller attorneys who are not making as much money as some people would represent them as making. So they almost unanimously do lots of user interviews. They almost unanimously report cost is important to them. Yeah. Any more questions? I want to try to be as thorough as possible, especially if I would also love to talk about some of the emerging markets here. So this might be an important one on where people are going to be able to see or access. Is there expectations of not proofreading AI docs? Perfect. Okay, for these two questions, I want to be clear. I'm not providing legal advice. I'm not a 3L, so very quick. I would say you should expect there will be some hallucinations if you're conducting legal research. If you're just doing a transactional document, I've seen they've come out pretty good on those. But if you're doing legal research, you probably should expect some hallucinations, at least in the pin citing. Decision-making, I think you're still going to be responsible as a fiduciary, same as if a lawyer made a major problem. Now, there are different questions. This is a very controversial legal question that actually came up both in the Delaware trial with Elon Musk and the Trump trial about fiduciary duty. And if you have an agent of the corporation acting, I think it's beyond kind of the scope. I think the case law is not well developed here, to be honest.
You were talk about
yeah.
emerging. Are you going to talk about the fiduciary? Or do you want to continue on that one, or you want to?
I'll very quickly cover the emerging markets. I know we're running out of time here. A lot of these emerging markets are not properly digitized, so it has a massive ability for startups to come in and create a data moat, which is much more powerful, in my opinion, when it comes to AI, because technical moats, there's a question if you really have IP on them. And a lot of this is going to be evolving rapidly. So data is king. We've always known this with AI and machine learning. A lot of this, too, has to do with integrating into verticals immediately with American corporations who are very interested in complying with American law. Peruvian law, for example, can sometimes conflict. Resolving those conflicts of laws is a really difficult and important niche issue. And I think we're going to see a lot of competitors, especially coming out in other countries like India, China, trying to solve that issue automatically. On the transactional doc, likely not, well, it depends who you believe. There haven't been a lot of comprehensive studies on the transactional side. The ones I've worked with were quite well, but they're just basic contract stuff. Honestly, I think ChatGPT does those pretty good. Okay, I just want to quickly end with, I really appreciate being here. And if you have any more questions, please feel free to contact me. Yeah,
well, let's just if you got just a few, what we want to also just hit on, there was some, well, first, any other questions that people have? If you do, you can send them to us. We can then relay them on to you, Kimo, and to Patricia. There was on terms of future events, future topics. There was one topic, which is what percentage of AI projects are actually implemented. That comes from Andy Fish. That's not a legal tech question, but more to you, Patricia. I guess the answer was it's less than 10%. So it's an interesting, and maybe they're sort of still in the trying to get across the river or whatever it is. Another thing that's relevant for everyone is tomorrow we're going to talk about tech weeks. The next 2 lunches, you guys can join those by Zoom. So it's tomorrow at 12 Eastern, and June 11th is 12 London time. So it's a breakfast. You are both welcome. Everybody's welcome to continue these discussions on those. I always think the theme is sort of tech week takeaways. New York is this week, London's next week. And yeah, I think this, if other people have we can have this legal tech part 2. We can continue these discussions. But any last comments, questions?
Yeah, we'll just maybe thank everyone again as well. And I see a few questions about deals. Feel free to reach out to us. And as we mentioned, we will be closing this pre-seed round very soon. There's a lot of interest, so it's probably going to be closed in the next 2 weeks. So feel free to reach out. Mark knows how to connect us.
Well,
so,
you can provide your contact info.
Sure, let me do that.
And we met Kimo, and it was still sort of cold in MIT land. When was that? March?
Yeah, that was way back in March. That was fun. It's a little warmer now.
Yeah.
Super. Thank you so
Awesome.
much, Mark and everyone. Appreciate it.
It feels like you should produce a thought leadership piece for for us all to look at, if you haven't done one of like a.
I will love to. I'll write. I'm thinking about writing a.
For yourself, but we would love to digest that. And so put all this into. So we recorded it. Maybe this will catalyze a part 2 discussion. All right. Thank you, everybody.